Resuming debate, the honourable member for Thornhill.
Thank you, Mr. Speaker, and I'll be splitting my time with the member for Durham. Mr. Speaker, I think it's important for Canadians to realize that the legislation before us now is neither the alpha nor the omega in the continuing conversations Canadians are having about physician-assisted death. The Supreme Court forced this legislative moment on reluctant politicians with the Carter decision, but the conversation has been simmering, occasionally percolating, for decades. In hospital intensive care wards and doctors' offices, around family dinner tables and at the bedsides of loved ones, from holy pulpits and at congregational retreats, in medical schools and law schools, by theist philosophers and by the atheist sort. And most personally, the conversation has been conducted within ourselves, in our own minds, in both sickness and in health. So, Mr. Speaker, if the proposed legislation before us is neither the beginning nor the end of our ongoing conversation about physician-assisted death, what is it? Where exactly are we? Well, first of all, I think it is abundantly clear we are definitely not where the Supreme Court told us to go. The legislation before us, which I believe will easily pass the House and should as well the Senate, is only, I believe, an interim step that will almost certainly very quickly lead us again to the Supreme Court. Now, the official opposition has set as its highest priority safeguards to protect the most vulnerable in society, as well as for the conscience rights of physicians and other healthcare professionals. We're pleased that the government accepted recommendations from the Conservative dissenting report from the Special Joint Committee to exclude minors, to include stringent safeguards to protect those with underlying mental health challenges, and to recognize the risks involved with advanced directives. I'll come back to that in a moment. But there are still concerns with the proposed legislation before us. First, a point that has and will be raised by colleagues many times, and I believe on both sides of the House, the lack of specified conscience protection, assurance that medical practitioners and institutions may decline participation in physician-assisted death. Now, I don't believe that should be a problem, Mr. Speaker, because I believe there will be no shortage of physicians willing to assist those patients who meet the criteria for assistance. Then, Mr. Speaker, there are the matters again raised by many of my colleagues of the need for greater provision for prior review of the consideration of underlying health issues and of possible psychological disorders on patient decision-making. I believe those matters should be thoroughly reviewed again in committee. Now, many of my colleagues have expressed concern with the extension of the Supreme Court's specific direction that physician-assisted death must be performed by medical doctors to also include nurse practitioners. We know the government's logic in broadening the responsibility for remote areas where qualified nurse practitioners now carry out many, very many, of the services traditionally provided by MDs. Again, I believe the legislation needs more specificity in this area. I firmly believe that many nurse practitioners are qualified, capable, and willing, but perhaps the legislation should explicitly state that nurse practitioners be engaged only as physicians of last resort in circumstances where no medical doctor is available. I also recognize the widespread concern and resistance, Mr. Speaker, to the vague nature of phrases within C-14, such as reasonably foreseeable. I personally accept such imprecise conditions because I realize that as magnificent as modern medicine is today, prognoses regarding the time of a final breath or a final heartbeat are still often only educated guesses. This is certainly worthy of further examination at committee. And finally, Mr. Speaker, one of the most important shortcomings in convincing Canadians to accept Bill C-14 is in the government's unkept, let's be perfectly frank, broken promise on palliative care. The Liberals made a campaign commitment to invest $3 billion in long-term care, including palliative care. The importance of access to palliative care in end-of-life decision-making was one of the few unanimous points of agreement in the Special Joint Committee's report. Now, Mr. Speaker, we as parliamentarians can rush to meet the Supreme Court deadline of June the 6th, but at the same time, the government has a clear duty, a moral obligation, to put in extra effort to expedite fulfillment of that promise to expand the availability of accessible, affordable, acceptable palliative care for all of those who, for reason of conscience or faith or choice, decide not to avail themselves of physician-assisted death. And I firmly believe that that choice must be extended, as I believe the Supreme Court clearly intended in the Carter decision, to patients suffering from specific diseases and conditions that formed the basis of the Carter decision. The brutally imprisoning final stages of spinal stenosis, the choking, smothering final stages of ALS, and the unrelieved pain of irreversible but interminably long final stages of progressive multiple sclerosis. And while I'm on this point, I remarked earlier on the need to recognize the risks involved in advance directives for diseases such as Alzheimer's, dementia, and the like. That said, I believe advance directives eventually be allowed in physician-assisted death. Mr. Speaker, I've consulted with many individuals and groups in my riding of Thornhill in recent months and beyond. I greatly respect, profoundly respect, the advice and interventions of various faith communities, social agencies, and medical institutions, and their concern of the need for greater protection of the most vulnerable. But my personal decision, which will determine my vote on this legislation, is a product of three individuals and their experiences. In my previous life as a journalist, I followed closely the unsuccessful legal crusade of Sue Rodriguez as ALS steadily increased its deadly grip, and her rhetorical question posed to Canadians, if I can't give consent to my own death, whose body is this? Who owns my life? In the previous couple of parliaments, I became close with another thoughtful, courageous Canadian, a fellow member of Parliament, the Honourable Stephen Fletcher, Canada's first quadriplegic MP, re-elected 3 times, just last month elected to the Manitoba legislature, didn't give up after his life-changing accident 20 years ago. He met immense challenges and he overcame them. But in 2 private members' bills tabled 2 years ago, which I seconded, and in testimony before the Parliamentary Committee this January, Stephen made a powerfully convincing argument for self-determination to one day make a final decision. He said such a law would be based on an individual's own morals and ethics, while he stressed that there should be no pressure on that person from society, family, friends, or the institution they may be in. I was also powerfully informed and persuaded, Mr. Speaker, by the tragically tortuous passing of my brother-in-law, Rick Davidson, a brilliant academic, to Alzheimer's. Should such an ending be diagnosed for me, I assure you an advance directive would be composed, and either unlaw or not, it would be fulfilled. Finally, Mr. Speaker, as a cancer survivor, I've had many hours of reflection during treatment and since to ponder the issues involved in this debate on a personal level. I'm fortunate that modern medicine, faith, and an incredibly supportive wife and family have left me, for now, clear and happily continuing my late life adventure as a politician. And I'm honored that I can participate in this debate to argue for the passage of Bill C-14 and eventual broadening of this legislation's provisions and immediate government action to expand palliative care facilities and services. Because, Mr. Speaker, in closing, I passionately believe that the issue before us ultimately comes down to choice. The free choice of a competent adult individual to choose between accessible, affordable, palliative health care and the constitutional right to physician-assisted death. Thank you, Mr. Speaker.
Questions and comments. The Honourable Parliamentary Secretary to the Prime Minister.
The issue of advanced consent or advanced care directives was spoken to in your presentation, to the presentation to the House, and the question I have is one about timing and how the timing of that could be spoken to in amendments to this legislation. How would you see advanced care in terms of, provided at the age of 20, when the person will encounter difficulties maybe 30, 40, 50 years later, or alternatively, upon diagnosis of a situation and immediately entering into advanced care directives. How would you see and how would you model timetabling around that so as to review the person's decision before the ultimate act is pursued?
Member for Thornhill.
Thank you, Mr. Speaker. I thank my colleague for a very thoughtful question, one that has been asked many times in recent months as the Supreme Court deadline has loomed. I think that there are a great many accounts written by Alzheimer's with significant medical and academic ability who compose diaries of their time of diagnosis and the observations of steadily diminishing capacity. And I think that there is a point, and anyone who has supported an Alzheimer's patient in the final stages, I'd be surprised if they would allow that they themselves, even though they might be unaware, continue to that final stage. The burden on family and friends and the medical institutions is overwhelming. And I think that there is a period, 15 days obviously doesn't work, but I think that there are some worthy accounts which can be referred to. There was a great personal diary in the New York Times Sunday magazine a few months ago about an academic who recognized and who provided, with mail-order barbiturates from Mexico, to be prepared when she realized she was in the last stages herself of fully controlling her life and her situation. And I think that physicians expert in this area could provide us with answers to your question.
Questions and comments. Kese Kamantaya, the honourable member for Wellington, Halton Hills.
Thank you, Mr. Speaker. I want to thank the member for Thornhill for his thoughtful views on this bill and for his personal stories relating to the bill. My question for him is that in his speech he mentioned that he did not believe that this bill was compliant with the Supreme Court of Canada's ruling, the Carter decision as it's often referred to. Could you tell the House in what ways does he believe this bill is not compliant with that Carter decision?
For Thornhill.
Well, thank you, Mr. Speaker. And again, I thank my colleague for a question. Well, the reality is that the three parties to the Carter decision would not be assisted by C-14. And I listed the three conditions, spinal stenosis, ALS, and multiple sclerosis. All three of these particular afflictions would require additional legislative provision, and I believe that is why we will very soon be back before, or the legislation will be back before the Supreme Court to order an extension of its provisions.
Question commentaire. La députée.
The honourable member for Sherbrooke. Thank you, Mr. Speaker. I'd like to thank my colleague for his speech. I was wondering what he thinks of the government's choice of a different definition from the one in the Carter decision. That definition was uncurable, and the government decided, knowing full well what it said in Carter, what the Supreme Court said, the government chose a different definition. What does the member think of that choice?
Je voudrais remercier mon collègue.
I'd like to thank my colleague for his question. Mr. Speaker.
Politics. As we have seen characteristic of the Liberal government in recent weeks and months, they are reluctant to reach difficult decisions. There is an attempt to keep everybody happy on every file, procrastination and avoidance of the tough decisions that need to be taken. And I think that this is another case. We've seen it with pipelines, we've seen it with military missions abroad, we've seen it with the environment. But I think in this case, risk aversion has basically brought the government to enter a piece of legislation which doesn't go, as I said, where the Supreme Court ordered us to go.